Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Understanding what voids a deed is crucial for anyone involved in property transfer. A deed is a legal document that officially conveys ownership of real estate from one party to another. However, specific defects or circumstances can render a deed entirely invalid, meaning the property transfer never legally occurred, even if the document was signed. Let's look at some common reasons why a deed intended to convey property would be void, meaning it holds no legal effect from its inception. One major reason is fraud or forgery. If a deed is signed by someone impersonating the true owner, or if the true owner was tricked into signing a document they believed was something else entirely, the deed is void. It's not a legitimate transfer. Similarly, a deed signed by someone lacking mental capacity is also void. This means the person transferring the property did not understand the nature and consequences of their actions due to a mental illness, severe impairment, or being under the influence of substances. They couldn't form the necessary intent to convey property. Another critical factor is duress or undue influence. If someone was forced, threatened, or pressured into signing a deed against their will, the transfer is not voluntary and the deed is void. It must be a free and willing act for the transfer to be valid. An improper or inadequate legal description of the property can also void a deed. The deed must clearly and unambiguously identify the exact parcel of land being transferred. If the description is vague, incorrect, or missing, it's impossible to know what property is being conveyed, making the deed ineffective. Furthermore, a deed requires delivery and acceptance to be valid. The grantor must intend to transfer ownership and physically or constructively deliver the deed to the grantee, and the grantee must accept it. If the grantor signs a deed but keeps it, or the grantee refuses it, the transfer isn't complete and the deed is void. A deed created for an illegal purpose is also automatically void. For instance, if the property is being transferred specifically to facilitate criminal activity or evade creditors in a fraudulent way, the law will not uphold such a transfer. Any material alteration to the deed after it has been signed and delivered, without the consent of all parties, can void it. This means changing key terms, names, or property descriptions after the fact. Finally, a mutual mistake by both parties regarding a fundamental aspect of the property or the transaction can sometimes void a deed. Both parties must be mistaken about a core fact for this to apply. These scenarios highlight why vigilance is essential when dealing with property deeds, as a void deed means the intended ownership transfer simply never happened and the property ownership remains with the original grantor. Thank you for watching this explanation of what can void a property deed. If you found this information helpful, please give this video a thumbs up and consider subscribing to our channel for more valuable insights into real estate and property law. We appreciate your support.